Good morning, everybody. I'm here with Cindy Blackstock this morning to talk a little bit more about some of the recent developments in the ongoing Canadian Human Rights Tribunal case for justice for First Nations children and youth. So I'll just start with the first question that I have here for you, Cindy. Why did the Canadian Human Rights Tribunal order Canada to pay $40,000 in Canadian Human Rights Act compensation to eligible victims?
Well, one of the reasons is that Canada was found to be discriminating against First Nations children and families by providing way less funding for child and family services, also known as child welfare. And they failed to implement Jordan's principle, and the consequence of that was that many families were separated unnecessarily because they didn't get a chance to have prevention services because there were no prevention services funded by Canadian government. And on the Jordan's principle side, we saw children who had real needs for medical, health, or social supports, and they were denied those things by the government of Canada, which meant children with autism weren't provided the supports they needed to live the lives that they could have. Or children with certain medical needs were denied those. And in fact, the tribunal has linked Canada's denial of services under Jordan's principle to the deaths of children. So the Canadian Human Rights Act allows the tribunal to award a maximum of $40,000 to victims. And the tribunal said this is a worst case scenario of discrimination. And so each of the eligible victims is eligible for $40,000, and it can go back a year before the complaint. So the complaint was filed in 2007, so the compensation period begins in 2006.
Okay, and did Canada ever appeal the Canadian Human Rights Tribunal orders? And if so, what happened there?
Well, of course they appealed, and they appealed because they didn't want to pay the victims anything, and that's really important. The politicians were out there saying, well, we want to compensate people. Well, their legal documents said, we don't want to pay a penny. And that was consistently Canada's position up until about a year and a half ago. So it was saying, we don't want to pay anything. And they were actually saying because it was systemic discrimination that hurt these children and their families, that was the reason that Canada shouldn't have to pay. But it was Canada doing the systemic discrimination. So the federal court was not happy with Canada's arguments. So on September 29th of 2021, the federal court dismissed Canada's appeal. Canada, though, it's always in it, and it decided to file another appeal. So that appeal is now with what's called the Federal Court of Appeal, which is, one level below the Supreme Court for people to know. So the Supreme Court is the last court, so we're at the one just below it. And that's just kind of hanging out there for right now. We don't know what's going to happen there, but a key date to watch is December 12th, because that's when the Federal Court of Appeal wants to hear back from us.
December 12th, okay. And why has Canada not paid anything to the families and children that it hurt, even after it was ordered to do so?
Yeah, after not only a tribunal order, but a federal court order. Well, Canada is basically choosing not to pay the money. And some of you might remember the Prime Minister during the election debate, and as well as ministers after, said, you know what, since the Canadian Human Rights Tribunal ordered us this $40,000, a couple of class actions have cropped up. One of them headed by the Assembly of First Nations, another one by a group that's representing Xavier Mushin and Zach Trout. And they said, what we're going to do is we're going to try to absorb all of these Canadian Human Rights Tribunal victims into this class action. We want to give these people who have $40,000 more money.
Right.
It sounded good, but I wanted to see the small print.
Mm-hmm. So what are the differences between this class action that you're talking about and the Canadian Human Rights Act compensation?
Well, for the Canadian Human Rights Act, it can award up to a maximum of $40,000 per victim, and that's what they did. And those victims retain their legal rights to sue for more money if they feel that the harms were more than that. And there's no cap to the amount that Canada has to pay. Basically, every eligible victim that comes forward is entitled to the $40,000. And the other important thing for people to know is nobody gets any money. So the Caring Society is not going to get a penny. No lawyers are going to get any money under the Canadian Human Rights Act. All the money goes to victims. And the Canadian Human Rights Act also has the ability to order supports, which they did for victims. So that's the Canadian Human Rights Act. Now let's look over here at the class action. let's start with some of the good things. It can go back as long as it wants. So in this case, it went back to 1991, including far more people. That's a good thing. And it also included more kind of groups in there. So for children in care, there's a couple more groups that would be eligible that are not eligible under the Canadian Human Rights Act. So that also is a good thing. Now let's talk about some of the limitations. In a class action, there is a legal fees, and they can be quite substantial. So the lawyers who are part of the class action, and they will get a substantial payment at the end of this. We also have the issue of the lawyers in Canada agreeing to a $20 billion cap. Now that's a huge amount of money, Molly, but when you look at the number of people that Canada hurt, it's turning out to not be enough money. It's just, you know, we think about hundreds of thousands of people here who were really had their lives hurt in a very significant way. And so when you do the math, it turns out that some of those people who are entitled to $40,000 actually aren't going to get more, they're going to get less. We'll get to that in a minute.
Right.
So the class action is a separate legal proceeding. That's what people need to know. And it was possible for these things to continue on in two ways. Canada meets its Canadian Human Rights Tribunal obligations, and then it pays more through this class action. But it was Canada that tried to blend them together to make sure that they didn't have to pay the money that they were ordered to pay.
So a couple of really substantial differences between these two processes. Who are the parties in the class action regarding Child and Family Services and Jordan's Principle, and which victims are covered?
Okay, so that is the groups are the Assembly of First Nations, the Soto's law firm out of Toronto, and Kugler Clan Design out of Montreal. Those are the legal firms. There's a couple others as well. One here out of Ottawa, and another firm out of Vancouver. So there's about 5 or 6 of these legal firms, but those 3 are the top ones. And then they're representing what are called representative plaintiffs, which are folks who are they're kind of chosen to represent the harms that people have gone through. And so you'll hear the name Moucham quite a bit, and that's because Xavier Moucham, a very courageous young man from Quebec, who was in care, went through unbelievable number of placements, has said, I want to stand for justice, and that's a good thing. As well as Zachary Trout, who was a parent of 2 children who were denied services under Jordan's Principle, even though those children were in palliative care. So there's some representative plaintiffs there for the one class action, and then on the other side we also have representative plaintiffs. So Carolyn Buffalo, Ashley Bach, and more.
So why did Canada and the AFN bring a motion back to the tribunal asking for approval of their class action agreement?
Well, it wasn't necessary, but Canada insisted on a clause in their class action agreement, and that clause said that the Assembly of First Nations would publicly defend this, not only in court, but also in the public. And so they said, look, we don't want to pay the $40,000 we owe on the tribunal on top of what we are agreeing with you guys, class action lawyers. So we want you to make those orders go away at the tribunal. And the way to do that is to bring your whole class action agreement and say to the tribunal, here you go, you need to agree with us that this is good enough for kids, and your order would then go away. That's what they mean when they talk about fully satisfy the order. So that's what the request was of the tribunal.
I see. And what did the tribunal decide?
The tribunal noted that its job is to affirm human rights, and where there's breaches of human rights, to remedy that, order remedies to that. They have no jurisdiction to take away human rights that they've already recognized. And in this case, they found that the class action, although it's got many positive elements to it, it would actually take away $40,000 checks from children in care and other the estates of parents, and leave them with nothing. And for others, it would reduce the amount from 40 down to about half of that. And for others, the entitlement was unclear. And for those reasons, the tribunal said we can't abandon our orders. Because abandoning these orders means abandoning these many victims across the country who have suffered at the hands of Canada and who we've already legally found to be entitled to $40,000 in compensation for that wrongdoing. The other thing that's interesting is some might remember in the headlines out of Manitoba, there was a case that's somewhat similar, and that was the Manitoba government was taking the children's special allowance that was supposed to go to children in care and keeping it for itself. And the Court of Queen's Bench in Manitoba said, no, Manitoba, you can't take money that's entitled for children in care. And that's really what's at play here, is that the money actually doesn't belong to the class action orders, it doesn't belong to the tribunal, it doesn't belong to the caring society. The only people it belongs to are the youth in care and the victims. And they're the only ones who can say, yes, I want to give that money away or not.
Of course. And does the tribunal's compensation order also mean that the $19.8 billion over 5 years in prevention and other services is in jeopardy?
No. About 75% of that $19.08 billion is already covered by existing Canadian Human Rights Tribunal orders. And the prevention money in particular, I saw in the news some people saying, well, it's going away as of April 1st. Well, that's not what the tribunal has said or ordered. The tribunal just this year said that the $2,500 per person on reserve in prevention money continues ongoing, adjusted for inflation and population, until long-term reform is implemented. And that means until they grant another order. So they need to see something that would improve lives for children. The other thing to watch for is that $19.08 billion. That sounds like a lot of money too, over 5 years. And what we have to figure out is what happens to children in year 6 and beyond. First Nations communities across the country have told us that they want to see the discrimination stop forever, not just for 5 years.
Of course. So what are the next steps for compensation?
Well, we've certainly reached out. We see a pathway to success of ensuring that the tribunal's orders are upheld, and in fact the tribunal provides a pathway for that to happen right in its orders to the class action people. So we've reached out. We see a path for success so that all the victims get the compensation they're legally entitled to. And we're hoping that the other parties will return to the negotiating table and do the right thing. So that's what's next on compensation. Also, keep in mind, Canada can pay the money it legally owes these kids under the Canadian Human Rights Tribunal orders overnight, literally. Mm-hmm. And some people say, well, it's too difficult. And I said, well, remember in the pandemic with the CERB payments? That happened pretty quick, and so this can happen pretty quick too. They just got to choose to do it.
That's right. So what are the next steps on long-term reform?
The next steps on long-term reform is there's community-based research. I am a big believer that the best solutions for kids actually come from the communities themselves. So there's this community-based research happening, and to call it research kind of almost dismisses it. It really is about incorporating the voices of First Nations and First Nations child and family service experts across the country. We need that work to continue, and then we will be proposing a long-term funding approach beyond year 6 that ensures the non-discrimination of children into the future. So that work is still continuing, and certainly we're doing what we can to keep everybody informed and also to invite their ideas, because some of the best ideas come from communities themselves, and we want to make sure that we're setting a minimum standard for which Canada can't go below, but also allowing for the creativity to happen at a community level to adapt to the needs of the kids and their circumstances.
And that's all great. You mentioned keeping people informed. How can people learn more and keep up to date with all of this information?
Well, you can go to our website, fnwitness.ca, and read all the legal documents yourselves. I think that it's really important to be accountable. So you can see what we're saying, you can see what everybody else is saying, and I think that's important. There's also a website for class action on the Child and Family Services side. Go to the Assembly of First Nations website and you'll be able to look for updates there on the class action elements. And we'll have another conversation when there's more to report on the class action as well as on compensation and long-term reform.
Well, that sounds great. Thank you so much for all of the information.
Thanks for having me.